So let me start with a nice phrase: truth fears no trial. This phrase was given by Thomas Fuller, an English churchman and historian, and one of the first English writers. So as we move ahead, trial is a very, very complex uh, thing in law, and each one would find that it is one of the most difficult aspects of law as one would know it. But let me try to make it as simple as possible for you guys. So we had stopped rather at the framing of issues. And now let us go to this trial. Now, I am not essentially going to be talking about trial in criminal matters, but we are restricting ourselves only to civil matters. So let me start with the topic of admission, just to give a recap and just to give a continuance to the last topic that which we had. So we had admissions which were taken from the clients by virtue of, either a notice which was issued to them, or in terms of a letter which a solicitor would have written to them, asking them to give us the admitted facts and documents in regard to that matter. What this really helps is to curtail the trial in terms of proving of a particular fact or document. So essentially, these admissions do help in curtailing. The provisions which are relevant provisions here would be Order 12 CPC, read with sections 17 to 23 of the Evidence Act. So no proof or evidence would be required on admitted facts. This is what admission would help us do. Once the fact is admitted, no proof of this would be required to be proved by and way of either oral evidence or by way of an affidavit, which you may have to file at a later stage. Now, if we say this, can I also ask Kingshuk, because this is one topic which also requires a solicitor from his perspective to tell us what he would like to say on this topic.
Yeah, I think, Kamal, you're absolutely right. This is, I think, one provision, at least in my sort of experience, that I have seen parties and lawyers not use enough. It's available in the CPC, but I don't really see in the course of proceedings a provision to be used enough. As you said, I think the provision saves a great deal of trouble because it reduces the burden of having to prove documents and facts that are undisputed. And so I personally feel that one should focus more on this, and as a matter of routine, one should issue notices to admit documents. Of course, on the form, what it must contain, all of that is contained in Order 12, and I don't want to get into all of that. But it's good to sort of identify key documents, key facts that are relevant to the case and would sort of have a bearing on the outcome. And one should consider issuing a notice to admit, because also Order 12, and Kamal, you can probably come in here, also provides that there is a sort of a deeming admission if there is no response that comes in. So it's not a provision that requires a response to be given for it to be considered in by court. But even if a party does not respond to this, it is deemed to be admitted. So that's and I think that's very important to sort of keep in mind.
Yes. So Kingshuk, I essentially did not get deep into the provision because I would want the lawyers as well as students or interns essentially to look at these provisions. Our idea today is to point out the provisions and the sections both. So there is a comparative chart where you are looking at the CPC as well as the Evidence Act to get into just the overview, so that a person will have to look at these particular provisions, looking at the facts and circumstances of each of these cases, and they must read the provision. I'm not here basically to suggest in which fact and which circumstance which provision will apply. I am merely giving an overview so that it is a guide to the persons concerned, whoever is looking at it, and whoever is doing it, may it be an intern, may it be a solicitor, may it be a junior advocate or otherwise, but they would have an idea as to how one needs to move ahead. So once you read, because the general tendency today is once you are asked to really, go ahead with the conducting of the suit and to probably file an affidavit, people without reading these provisions and without understanding them, they start filing the affidavit. And that's where the basic problem arises. So in order to get over that, I'm simply giving these provisions so that the idea is to first look at them, read them, study them well, and then proceed. The idea with which I have not gone deep, as you have rightly gone and said that yes, you must consider the admitted facts, and those admitted facts you don't need to prove, and those are deemed admission. I completely agree with you. So now going to the next point, which is settlement of issues. Okay, so now in settlement of issues is basically what? It's a determination of suit on issues of law or issues agreed upon. Okay, now this is covered by Order 14, read with, CPC, read with chapters 7, sections 101 to 114A of the Evidence Act, which deal with the burden of proof. Okay, after considering all the assertions, okay, and denials or contentions of both parties, one needs to frame an issue. So basically, what is an issue? We need to consider all the assertions of a party and the denials or contentions of the other party, and then you can frame an issue. So essentially, an issue would be such that it would cover most assertions and denials under one head. What I mean here is that if there is a case of specific performance, illustratively, where you are seeking damages, and also there is a case of fraud somewhere, then one may frame distinct issues. So such as, if I may give an illustrative example here, whether there was a breach. So the first of the issues would be in a suit for specific performance, whether there was a breach. The second one would be whether the plaintiff or the party would be entitled to specific performance. The third being whether the plaintiff would be entitled to damages. And if we look at what is the relief ultimately that he gets, that will be the last of the issues for the plaintiffs, but where the defendant would be concerned, whether the defendant proved that the plaintiff had failed to perform his part of the contract. So this is where the denial and or the assertion of the defendant or the other side would come in. And then whether the defendant proves whether he was not liable, that is, the plaintiff was not liable to perform on account of breach. So, and he did not, that is, the defendant did not perform because the plaintiff had committed a breach. So if this is normal, this is the normal case, I would say, between the plaintiff and the defendant in a suit for specific performance. Now, these are the basic issues which would be required to be framed. And most of the other assertions and denials would be coming under each of these heads. So typically, if there is another assertion made by the plaintiff in the suit, that would have to be considered, and the denials too will have to be considered to frame that issue. I'm just giving you a broad aspect. Now, if there is a case of fraud as well pleaded in such a suit, then there, yes, whether a party has played a fraud. So whether a fraud is played by X on Y or Y on X, which will also have to come in as an issue. And this is how an issue would be framed. So there would be probably typically 5 to 6 issues and not more. Maybe, of course, in different facts and circumstances of each case, you may have additional issues, but it cannot definitely be. Now I'll tell you this, and why I have emphasized this is because I have seen that in matters, people have, basically taken each of the assertions in the plaint and each of the assertions in the written statement and formed an issue. So every assertion, like if you have say 40 paragraphs of the plaint and 40 paragraphs of the written statement, or maybe 80 paragraphs of the written statement, people would have almost 30 to 35 issues. That's not what is required. We need to see that those assertions which can be covered under a particular head should be covered, and accordingly an issue has to be framed. Otherwise, it doesn't come, means every assertion does not necessarily form an issue, is what I would like to tell you here. So after this issue is framed, we then have to give a list of witnesses.
Kamal, may I just come in here very briefly? You know, one, I think important, I think you've kind of laid emphasis, and the importance of this stage is really something that is not taken seriously, because much of what we do after and what you will be talking about really is dependent on the issues. So one should be careful in framing the issues. So that's goes without saying. One, I think, interesting aspect of issues that perhaps it's maybe a good idea to talk about are threshold issues, because as a defendant, you know, it's you would want your suit to be dismissed as early as possible. And so as a defendant, it's a good idea to look out for threshold issues that can put an end to the matter without really going through the rigmarole of a trial. And that is also covered and, you know, contained in Order 14. So issues relating to, say, jurisdiction of the court, or, you know, a bar to a suit, are often considered threshold or preliminary issues. And look out for those issues, because if you have those issues, then as a party, as a defendant, you should ask the court to frame them as preliminary issues and decide, because that's something that the CPC allows you to do. So that's something to keep in mind.
So you're absolutely right, Kingshuk. And yes, of course, when I was talking about issues, I didn't really go into the deep aspect and averments of the plaint. But you are absolutely right that one needs to look at the plaint, needs to understand whether the jurisdiction, the limitation, and the res judicata, because these are the three aspects which I had covered on the previous occasion, and which were the basic clauses of a plaint which were required, right? So I had covered this aspect in the previous webinar, and as a result I had not repeated it, but I'm thankful to you for having said this. So yes, of course, when a plaint has these three important clauses, the averments in the plaint which we say have these three important clauses, without which a plaint would be incomplete, because here, before admission of the plaint itself, one has to see whether the particular court would have jurisdiction, whether it would be within a limitation, and whether or not it is barred. So if there was any other suit, these were the most important averments which were required to be there in every single plaint. So yes, of course, these will definitely form the three preliminary issues if at all there is a denial. So you may have a denial with regard to jurisdiction. Yes, you're right that in most cases, or rather many of these cases, you could raise this issue at least of limitation, if not jurisdiction. You may have jurisdiction, but you may not have limitation, and they may have come a little belatedly. So you would be completely right, and I totally agree with you there. So taking this from issues, can we then go further to the list of witnesses? Okay, so now having got these issues framed, generally what the court does is to ask the parties to exchange a list of witnesses. Now this again is covered, say, in chapter 9 and sections 18 to 134 of the Evidence Act. Okay, now this I would say is one of the important aspects, in my opinion, because it's not only about giving a list of witnesses, right? So if one must consider, okay, which are the witnesses you are going to examine in the first place. You must bear in mind that you don't have to give out an exhaustive list of witnesses, because that would probably cause a difficulty in withdrawing a particular name, because there is a possibility that the other side may call upon your witness as a witness for himself, and then try to examine him, and where you've already proved a particular point or a fact or a document or a series of facts and documents, you may not want an additional witness coming in. So this is a particular thing which could be avoided in the list of witnesses, and it definitely has a very crucial bearing on the trial. So I would suggest, in my opinion, that you must be very, very conscious of the fact of the list of witnesses that you give to the other side, whilst creating this. So I would really make my emphasis on this point, that please make a note of this. And similarly, for the defendant as well. So the defendant, essentially, I would say, that does not require to immediately give a list of witnesses, maybe only one or two, which are their main witnesses, if at all they need to give. And I would say this, that you should withhold this and seek liberty of the court or leave of the court to give you a list of witnesses later, and not at the first instance, for the simple reason that there may not be a necessity to examine any witness at all, because you may have been able to disprove a particular fact or a document or a case of the plaintiff, and you may not require to lead any evidence. So therefore that particular aspect has to be kept in mind. So at the highest, as a matter of precautionary measure, you may give the list or as a one or two names where you need to prove your case. So maybe it may be a defendant or a particular witness whom you may feel extremely essential for either proving your contentions or case. So this is what I would like to say in terms of witnesses. Now let me go to the next topic, which is Kingshuk, would you like to say anything on this, on the list of witnesses?
I think you've covered just a couple of points. I think,
Right.
and I'm certain that you've covered in the beginning in your first lecture the
Yeah.
importance of having a conversation with your client to understand the facts, to get hold of the documents. And I think a part of that exercise should also be, even before you file your proceedings, even before you file your written statement, to try and identify your witnesses. Leaving identification of witnesses too late could be a problem. So it's a good idea to gather your evidence, whether it's in the form of oral testimony of a witness or in the form of documents. Do it at that stage, because there are various factors that come into play. And from a practical perspective, what I've seen is, the personality of a witness, his ability to sort of withstand cross-examination, all of these are factors. So therefore, while you may have a witness in place, it's good to sort of familiarize yourself as a lawyer with who the witness is going to be. Not, I personally would recommend, don't wait until after pleadings have been filed, issues have been filed. Of course, the issues will determine whether those witnesses you want to now put in the box or not. But do identify the witnesses right in the beginning and don't wait till the end. So that's important to sort of bear in mind. And this applies not just to, say, a fact witness, but also to a expert witness. If you require an expert witness, again, don't go hunting for an expert witness after issues are framed. It's a good idea to identify your expert witness at the outset before you file your pleadings, because even, and Kamal, would you agree that your pleadings also, what you put in your pleadings, will have a bearing on the kind of conversation you have with your witness, whether a fact witness or an expert witness?
Absolutely, Kingshuk. In fact, yes, there have been cases where expert witnesses have been required. And as you rightly said, that once you have the case at hand and you've gone through the pleadings of both the parties, you are well aware of whether a witness or an expert witness would be required. And at that stage, when you study and you are about to frame your issues, and when you're going in for filing of your affidavit of evidence, and before doing that, I am sure that you have, and I'm certain that you have decided whether you would require an expert witness or not. And if you do, then it definitely makes sense in putting it in and presenting it to the court, because the court would also know the kind of time that the trial would end up taking. So yes, Kinshuk, you are absolutely right on that, and thank you for that. So now we'll take it further with regard to affidavit of documents and affidavit of evidence, these topics which are covered by Order 19 of the CPC. Now, affidavit of documents essentially contain the list of all documents in possession and which are to be produced by a party to prove his case. Okay. Now, these are the list which, of course, after studying of your entire case, we would require you to prepare the whole compilation. You may have referred to and relied upon certain documents and your certain things which you may not have annexed to the plaint, but you must gather all those documents. There might be certain correspondences between the parties which you may want to place before the court. All these require to be compiled and filed in the affidavit of documents. There are stages when if you do not essentially disclose all the documents which you have given under the affidavit of documents, there is every chance that the opponent would take an exception and oppose the further production of these documents with regard to since you have already filed your affidavit, because this particular step is essentially to warn the other side, or rather disclose to the other side what and how you're going to be proving your case. Okay, Kingshuk, would you have any inputs on this as well?
No, I think nothing specific. Kamal, you've, I'm sure, already covered the importance of gathering documents at the outset. I have nothing further to add.
So yeah, as it would be that yeah, if you don't, there would also be suppression of documents, which is one of the defenses
Correct.
that a defendant may take if you don't tend to bring those documents at the time when you file your affidavit.
The only point that I probably would want to re-emphasize is the
Yes.
importance of asking your client, and from an attorney's perspective, this becomes a bit of a challenge,
Yeah.
that asking your client to really come clean with all documents. Because often what we see is, you're only given documents that help their case, and documents that are not sort of in your favor are not spoken about. So it becomes a bit of a challenge. So therefore, please do bear this in mind. Get hold of all documents, so that there is no googly at the end of your matter.
Yeah.
That's the only comment that I have.
No, you are absolutely right, because there are stages and there is case law too on this, that when people have no choice, but then they, before the trial gets completed or probably even before the judgment, people tend to take out applications for disclosure of documents and trying to prove it. And courts have literally frowned upon these practices, although sometimes they're in a fit case or in a matter where it is required to be brought in, the courts have allowed the evidence to come in. But as you rightly said, one must dig deep into the client and his psyche, figure out as to what all things he is trying to suppress or he may have unknowingly or knowingly suppressed, and try to get all these documents in the first place. So yeah,
One other,
yes,
just when we are, these are thoughts just coming up.
sure, sure.
WhatsApp messages. I think you would agree, Kamal. Today, maybe 20 years back, what parties would normally, conversations that parties would normally have over phone or in person,
Yes,
are now being exchanged on WhatsApp.
correct.
So therefore, those, I think, mediums are also to be looked at in your filing proceedings. WhatsApp messages, or any other form of sort of social media exchanges. In today's day and age, all of that becomes very relevant to bear in mind when it comes to compiling documents. So do keep that in mind as well.
I totally agree, Kingshuk. That was a good input as well. Okay, so then now the next step would be filing of affidavit of evidence. So having basically spoken to your client and understood what it is, what is his case, and gathered everything, one needs to file his affidavit of evidence. Now this again is a very crucial step and a stage of the trial. This is essentially covered under Order 19 of the CPC, and this particular step is now taken up for the purposes of curtailing the oral evidence which was being taken up during the earlier years. Of course, now I feel that in the past 20 years, I've seen very few cases where oral evidence is led in court. In the city court, of course, there may be cases where oral evidence is led, but now in the high court, it's virtually minimal, and very rarest of rare cases or minimal few cases where oral evidence is led in court. So that of course is an art, because what are the questions put to the witness to get their oral evidence is an art by itself. But yeah, that is another topic altogether. And since we are not going deep into it, we are only dealing with the affidavit of evidence, which is normally what is done, and let's stick to that. So here, basically, an affidavit of evidence is now being filed in court, okay, to curtail the time of the court for leading oral evidence or evidence in chief. Now, let us understand what are the contents of the affidavit of evidence. Okay, the affidavit of evidence must contain the facts of your case and facts alone. We are not looking at laying down the law or what his understanding of the law is. It is basically what your case is, whatever your assertions are, whatever your facts are, whatever your interpretation of a document or a communication is with regard to a particular case. So, therefore, that particular aspect has to be laid down crystally in an affidavit of evidence. What you must also cover in affidavit of evidence is that this is an opportunity, or rather, this is the first opportunity where you are getting to deal with a written statement. So there are assertions made by the defendant or the opposite party in his written statements in the forms of denials as well as in the form of assertions. So if you have to have a say or something which you want to talk about with regard to the assertions or averments made in the written statement, this is the first opportunity which you are going to portray before the court to explain away what is either right or wrong, what the defendant has to say. And this is where the affidavit of evidence plays a very crucial part. Now, this particular aspect, the contents of the affidavit of evidence would be covered, say, from the Evidence Act perspective in Chapter 3, mainly sections 56 to 58. This particular sections talk about the facts that need to be proved or need not be proved. Okay, then chapter 4 sections 59 and 60 would talk about oral evidence. So basically the Evidence Act talks about these different aspects or different stages, that which facts you need to know which need not be proved, the facts which were required to be put in oral evidence. Then chapters 5, which is sections 61 to 90A, would talk about documentary evidence. Chapter 6, sections 91 to 100 talk about exclusion of oral evidence by documentary evidence. So, and one more, chapter 10, which deal with sections 135 to 166 with regard to examination of witnesses. Now, I'm mentioning these sections specifically so that before having to file an affidavit or embarking on the process of making an affidavit of evidence, the student or the fresher or a lawyer has to look at these chapters and study and understand these chapters so as to know what he needs to do in the affidavit of evidence. So what facts you would need to prove or not need to prove have to be ascertained very specifically before, and you don't need to reprove or try to again prove the document or a fact which have either been admitted or accepted by the other side. And we need to only restrain or restrict ourselves in putting out on the affidavit facts which are required to be proved. There are facts which the court may also take cognizance of. Those are separate aspects. So we are restricting ourselves to those facts and documents which require us to prove it. So a document, there is one particular chapter which covers documentary evidence. So whatever chapter 6 essentially talks about exclusion of oral evidence by documentary evidence. So this is very crucial. So one has to read and understand this to say what ought not to be put up as an oral evidence, because there is already a document. So when we say we would rather say that a document speaks for itself. You don't need to give emphasis on it. It is only and only when there is an ambiguity in the document or there is some sort of an interpretation to a clause or a document that you would want to give either in a communication which has already been exchanged between the parties, or by virtue of the document itself, if there is some sort of an ambiguity in a clause or an understanding, then to that aspect alone one needs to give oral evidence. So these are the contents essentially of an affidavit of evidence. Kingshuk, what would you like to add on this?
I think, Kamal, you've covered everything very exhaustively, but just some practical sort of pointers that I feel may be relevant.
Okay.
So, when you're drafting an affidavit of evidence, I think it's important to bear in mind that you're not drafting a pleading. It's not a plaint or a written statement that you're drafting. This, as Kamal said, is really an affidavit in lieu of your examination, your witness's examination in chief. So it's a transcript of sorts of the oral testimony of your witness. So that's very important to bear in mind. So keeping that in mind, how would I typically try and draft an affidavit? I would sit with my witness to the extent possible, or at least have a conversation with him before I start drafting, and not do it the other way around where I draft and do copy paste my plaint or my written statement and then share it. Kamal is smiling because I think he wants to say something, but it's best that you don't say it in this forum. But I think the point that I'm making is that, look,
I was talking about tutoring a witness. I was smiling.
Yes, I want to touch upon that point also, subject to your permission, when
Yes.
we speak a little bit about cross-examination. But
Yes.
I'm more on, at this point, drafting your affidavit. It's so sit with your witness, ask him a few questions as you would in an examination in chief, and make your notes, and then convert that into the affidavit, is how I would recommend that you do it. In the ideal situation, I know it's not always ideal. Sometimes your client picks up the phone and says, draft something and send me, and then we'll write it, then we'll think about it. But I would recommend approaching it in this manner, Kamal. And
Yeah.
so long as you don't give any illustration that involves me, I think I'm okay.
No. In fact, Kingshuk, as you rightly said, that you should not be, drafting an affidavit of evidence beforehand, even before asking, merely because the client has said. And I remember one such case where my clients and my attorneys insisted that I must draft an affidavit of evidence, even without sitting with the client. When I was constantly, as a junior, I was telling him, please don't do this, please don't do this. And they insisted that I do it. And then after having done it, they still did not make me sit with the client. And then we were asked to go and get it settled by my senior, Mr. Dwarkadas. So when we first went there, very unhesitatingly, I just told him that, sir, this is the affidavit of evidence. And he said, Kamal, have you sat with the client? So I said, no, Janak, I'm sorry, but they were in a hurry, and we therefore could not sit. So, with a very stern face, he just said that in our times, okay, and it was, of course, jokingly and mockingly, said in our times, actually, we would only sit with the client and draft affidavits and not otherwise. You wouldn't do it otherwise. So this only reminds me of that event that had happened with me personally. So anyway, so this is one of those things which I recalled, and I am presenting it to all of you all who are my listeners. So let's go take it further. Move a precipice, and then you would file this along with the affidavit of documents. And at that point of time, what happens is that a commissioner is generally appointed. Now the courts are not taking up cross examinations in court itself, save and except there are both parties who are desperate and they cannot get along before the commissioner. There are times, most of the times, I would say, and I think you would agree with me, Kingshuk, that in most cases, the evidence is sent before a commissioner. So now the commission court commissioner is generally appointed by the court by consent of parties under Order 26 of the CPC, and he has to tackle the examination of the witnesses who are presented both by the plaintiffs as well as the defendants. Okay, so now the role of the commissioner is what I would like to point out about. Here, the role of the commissioner is a very simple role. He is basically, a representative of the court but he has no powers as that of the court. So he's just an eye and ear for the court. And I say this because there are times when the commissioners tend to rule on things which is essentially not allowed. Now, the role of the commissioner under Order 26 is very aptly dealt by a case which is reported in 2008 6 BCR page 519, which is the Hemendra R. Ghia's case, and also in a case of Salem Bar Advocates Association reported in 2005 6 Supreme Court cases 344. If you all want me to repeat these cases at the end of this, I will again repeat it. But this is basically, these are two cases which lay down the role of the commissioner in recording of evidence. And there are therefore, there may be times where, the lawyers may have a situation where they have to restrain the commissioner from taking decisions. Basically, the commissioner is required to, you need to see as lawyers and juniors to see, and there are times, most times, that the seniors may or may not be present, or a counsel may or may not be present, and a junior is left to, sitting with the client through the examination process, because he is left. And there are times where you have a senior, and there are times where you don't. But when you don't have a senior, protecting you at that time, you must consider these aspects, and this is what is reported. So therefore, kindly look at these two case laws when you are asked to go to a trial. So these two cases are important, and here the role of a commissioner is pointed out. What is a commissioner required to do? He is required to be the eyes and the ears of the court. So he is required to report the demeanor of the witness. The demeanor means what? I should explain to the students. The demeanor would be that if a witness is asked, put up a question, or even if a question is put to the witness which he is not understood, the commissioner has to explain. And when he takes more than a normal span of time to answer the particular question, then in my view or my opinion, the court commissioner has to, by default, make a note and record it in that particular evidence which is recorded by him, because this is very crucial. Normally in the court, if a witness is taking more than a specified time, the court would immediately ask him to respond to the question and not give him an unlimited time to think and ponder over the question and then frame it and then give it. Of course, now when we see the examination of witnesses in a commission, we see the lacunae there, because generally what happens is the question is put up, the question is typed by the typist, the question is then asked to be repeated by the witness, which is obviously, like Kingshuk mentioned, that this are the points which the attorneys would tell their witnesses, that if you do not understand the question, please ask the question to be repeated. So it's not wrong, but yes, this takes away a lot of time, and the witness, as it is, has sufficient time to consider and ponder over that question, think about the answer, and then respond. But this, if it takes more than a reasonable time, I think the commissioner must step in and make a note of this demeanor in the evidence, and this is what I would like to say at this stage. Okay, so this is an important aspect, and both the parties should see, rather, who's witness, not the person whose witness is in the box, but the other side, must make it a note and tell the commissioner to record this demeanor. So this is what is there, and this is why I emphasized on this particular aspect as to what the role is. Secondly, the commissioner ought not to be appointed ought not to be ruling on any objections. So if there are objections taken by either parties, it may be for the purposes of putting up a question, or having put a question, the objection to the question, whether of its relevancy or otherwise, those have to be recorded the way it has come in. And it should be that every single aspect of what is going on before the commissioner ought to be recorded in the evidence that is going to be presented to the court. So this is with regard to the commissioner under Order 26. Whilst we are on this topic of commissions, the commissioner, I would also say that there are different roles of a commissioner. I had not pointed this out during the interlocutory stage, and which is what I would like to point out at this stage, because we are going through the conduct of suits as well as trials, that a commissioner could be appointed at any stage and of the trial under Order 26, Rule 9 of the CPC. Now, there is a particular judgment which also deals with the comparison between the appointment of a commissioner under Order 26, Rule 9 and 10 of the CPC, and under Order 39, Rule 7 of the CPC. Okay, there is a judgment on this, which is AIR 2014 Rajasthan 116 by Justice R.S. Chavan. Okay, in the case of Shafiq Ahmad versus Nasir Ahmad and others. It's a very interesting case, and the comparison shows in which cases commissioner be appointed and what would be the effect of that commissioner's appointment. So what would the commissioner essentially help the court in doing? The commissioner would, in my opinion, be able to give and help the court in deciding several aspects or facts which are disputed. Like I would say, Kingshuk, there was one case, I would say, and bring it out as an illustration, where, there was a society whose building was redeveloped. Okay, the case was that there was no building, and that the society had denied the very existence of the building and had denied that there was no work carried out by the contractor itself. So one would imagine that, okay, so what is the contractor asking or claiming the damages for? So since the society had not paid, the contractor had asked for the balance payments which he ought to have received. Interestingly, the society members had, without applying their minds, denied that he had carried out any construction. So, although it would be prima facie to say that how is it possible that the society members are saying. So, the first question which I had ended up asking my client, who was the contractor, is that are you suggesting that there's no building? Does the written statement suggest so? So is the building actually completed or not? So he says, of course it is completed and they are staying there. So one of the questions in cross-examination which I had to put up to the witness was that are you staying in the said building which this contractor has constructed? So it was so blatant and so evident. And then the total area of construction was also disputed. So at this stage, and this was the stage of the trial, having completed the evidences, we had to ask for an appointment of the commissioner, for the commissioner to go and check the total area of the entire construction that was carried out by the contractor. In fact, when we got a report, it was very, very useful for the court to decide on what is the quantum of damages and the claim, and whether the claim was correctly sought for by the contractor. But this is what happens, and there was an opposition with regard to the appointment of the commissioner as well at that stage, in view of the fact that they wanted to suggest, the other side wanted to suggest that you are collecting evidence for the purposes of improving your case. But this is what the court held in our favor ultimately, and said that no, this is not only this, and this case was essentially very, very useful. And that's why I pointed out this case of Shafiq Ahmad versus Nasir Ahmad, which points out and brings about the difference of appointment of commissioner and its usefulness. Would you like to add anything in this, Kingshuk?
No, I think very briefly, you've highlighted and emphasized the, I mean, if I may call it, the deficiency in the system, that today, unfortunately, a commissioner is not able to rule on objections and often is sort of required to be, or ends up being a passive sort of observer. But I think the point you make about the commissioner's power to record the demeanor of the witness, or for that matter, even, if a witness is being unduly badgered by, the cross-examiner, all of that, I think the commissioner is well within his power to make the recordings. And in my personal experience, early days in my sort of profession, there was a cross-examination where my witness was being examined. Though there was a lawyer on the other side, it was really the client who was running the cross-examination. And it went on for a year. a year and a half. The commissioner beyond the point said, look, there's nothing that I can do. So we had no choice but to go and make an application in court and say that, look, this is what is really happening in the commission. And the court did take notice of the conduct and said that, look, we'll complete the rest of the cross examination in court. We finished in the next 2 weeks' time. So the point is, if you feel that, look, it's being the system is being taken advantage of, it's not a bad idea to then try and make an application to court to see if the court intervenes and really comes to your aid to sort of overcome this otherwise a deficient practice.
Yes, Kingshuk, you are absolutely right. In fact, even I had such a case where the cross examination went endlessly, and we had to approach the court for getting an order, and the court definitely said that in the event that it is not completed by such and such date, then you shall bring it out back to me. And I must mention that this was because of Justice Khata, that ultimately ended that long drawn out cross examination, which went into 1,000 and odd questions, and the witness was cross examined for nearly about 2.5 to 3 months, which he was there, and he had come from states. So yes, you are right. And yeah, of course, when you figure out that the trial is being unnecessarily delayed and irrelevant questions are sought to be asked, you can bring it to the attention of the court, and you must. And I agree with you on that. So, taking it further now, with regard to the cross examination having completed, now this is what the recording is done. The entire cross examination is done. I am not delving into the cross examination aspect. Would you like to say something on cross examination? Because today we are looking at the conduct of the trial as a whole, and cross examination by itself is probably a very deep rooted topic, and it has several other subtopics which one needs to consider, and which may take us a lot more time. I don't think we would have so much time to delve into each one of those. So I am not getting involved in cross examination, because that by itself would take a session or two. So Kingshuk, I'm trying to just give an overview. So if you want to add something,
I think you're right. I think in the interest of time,
yeah,
let's not delve into that topic because we'll end up
yeah.
having to say a lot of things.
Yeah, so there even I have a lot of things to suggest, but we'll have to restrain ourselves in view of the shortage of time. So once this particular evidence is recorded, both sides witnesses have filled in their evidence. It is recorded by the commissioner. The commissioner is required to prepare a report, and along with the evidence and all the documents that have been tendered before the commissioner as well, the entire evidence goes before the court. Once this is done, okay, the recording of evidence is completed. The suit is generally listed for ruling of objections. Now, this is again another important stage where ruling of objections, which have been raised during the cross examination, has to be decided by the court. And I would like to bring out or emphasize rather as to why this is an important aspect. Now, once you have those objections, which have been recorded before the commissioner, uh, one needs to prepare a list of objections and the ruling on the objections, and bring it out before the court. And I would suggest that the lawyers and juniors or freshers should prepare a kind of a chart whereby you have objections, and you have your responses. Now, whilst you have been in the commission, it's like I would suggest that you don't need to get every reply to the objections recorded in court. I just missed out on that particular aspect, which I must point out, that you don't necessarily have to. You may, because there are times where you would forget, or you may not remember why you had, what would be your reply to the objection. You may record it, or you may not record it. If you want to save on time, you may make a note of it at a later stage and make a note and keep it. So, and you can always ask the commissioner to record that will be responded, this particular objection or objections would be responded in court at the relevant time, in order to save time, because generally the trials are delayed in view of these commissions. So, be that as it may, we must consider, getting this objections ruled on at this stage in by the court. What happens is that there are several probably documents, there are several facts, there are several assertions which are made, which are not allowed, probably are beyond the scope of the entire evidence, or beyond facts which have to be pleaded, or are not relevant to the entire case, which are now brought into the court record, in order to, consider, for the court to consider. And more often than not, the bulk of this documents and evidence would be such so as to, basically increase the bulk or the proceedings of the court. And it becomes increasingly difficult for the court to go for the final hearing and go through the entire bulk of the matter. So what essentially happens is, once you determine these objections, then that part of evidence and those number of documents are reduced, and as a result, the entire final hearing would be curtailed, and then you would be left to only dealing with those relevant aspects as per the issues, and we don't need to go into each of these irrelevant objections at that time, or at every stage of the point being argued. So if you have a particular point being argued in court, you would end up looking at the objection and the ruling or the responses at that point of time, which would delay, and the overview of the matter would be lost, because you do not have in courts, we are not being given dates even for final hearings on a regular basis, so it's not on a day-to-day basis. And what essentially happens is, once you break that link, again to go back into that and to deal with it, it becomes very, very cumbersome. So in order to help the court as well as to help the counsels of both sides, I feel this particular ruling of objections would be crucial. It also helps to deal with one more aspect, which is, that if suppose an objection is overruled, and a particular party feels, okay, that you need to lead further evidence to particular point, then this is the stage when the leave of the court could be taken, and you could lead further evidence. So this is a very, very crucial aspect which I would like to bring. And this of course would be seen, I must say that this is taken care of by the judgment in Hemendra Gia's case, where what happens pursuant to the ruling of objections. So this, therefore, I mentioned this particular case, that this is a relevant case when you're looking at examinations before the court commissioner. So this aspect also needs to be taken care of, and one needs to know that, okay, this ruling has to be completed. So this is how this helps. The next stage would be, deciding objections, and then we are looking at. So after this is done, we end up getting the matter listed on board, and then going in for the final hearing. So now, when we go for the final hearing, I have actually introduced this new system, okay, where I would collect all the documents and from both the parties and arrange them date wise. Kingshuk. So what I have done is that I would require the parties to arrange all the documents, and I think it is useful, and I would hope and pray that even the courts consider this at some stage, that if you have all the documents presented by both the parties, just collected and arranged date wise, and an index is prepared, okay, and you have those last two columns, whereby the document is presented by the plaintiff is in the first column, and the second column, the second last, means last two columns I'm talking about, the second column would have the documents which are listed by. So basically you will have a date, particulars of documents, or the list of documents which you are annexing, and then there is a column which will give you the page number. So if you have, say, illustratively a page number 1, which is the plaintiff's document, which is of a prior date, and the second document is that of the defendant, which is at page 5, then you would have that in the second column. So that is a simple way of pointing out that these are documents presented by the plaintiff and these are documents presented by the defendant. But this in fact helps you to clearly bring out the case, and there is no suppression. You don't need to look into different aspects of documents which are in different compilations. So this kind of a compilation definitely helps, because you have a pleading, that is your plaint written statement, and other affidavit of examination in chief and other evidences on one side, and you have documents. And if you have this kind of a list, definitely, the hearing becomes much smoother. Now, I leave. Would you like to add something to this, Kingshuk, before I
I
proceed?
think I think just some very quick points from a final hearing perspective. And I think Kamal, your this I think was great, this input, because organizing your documents is, I think, the key to really having an effective sort of final hearing, and that's absolutely of paramount importance. And that's really my first point also, that especially from an attorney's perspective, often. What we need to do and what we should do is try and ensure that the court's records are complete. They are duly organized and paginated, because as we know, suits in our country could have been filed in the year 1990, but will probably be taken up for final hearing in 2020. So it's a good idea to first start by, I think, organizing the court's records by consent. Of course, both parties can go and help the court organize the documents. And what, of course, I try and do just to ensure that there is some sort of parity is mirror my records, mirror the court's records really, so that they are arranged in the same fashion as the court's records, so that when I'm turning a page and when I'm looking at the document, a particular compilation, the court is looking at the same document. Some other, I think, points from a practical perspective, which will help in sort of ensuring that your final hearing is smooth. Keep copies of bare acts, keep copies of judgments, keep a few extra sets of the records, because court may not find one affidavit and you don't want the matter to be adjourned because of that. Your client is not going to be pleased, so you should have a few copies ready handy to of course clean. Don't have your secret notes in there. You don't want to let your secret out, so keep a few clean copies sort of ready. And I think one point that I want to make, overarching point, and this is something that I've come to learn, is that as a junior advocate, your level of preparation should far exceed your seniors, because for all practical purposes, you should be in a position to argue the matter and argue your brief, because that will not just give you confidence, it's going to give confidence to your client, it's going to give confidence to the counsel who's arguing the matter. So your level of preparation should be much higher. Even today, when I'm sitting with a senior, like say Kamal, or any other senior in the profession, my level of preparation would be much more than what I would prepare if I was arguing the matter myself, because I am responsible, and that's, I think, important to sort of make a note of. What else? I think it's useful to have a note, sort of brief 3 or 4 pager, which is very exhaustive in the sense that it has the dates, the facts, and also the page numbers which you want to refer to. Because if you have a voluminous record, you don't want to be sifting through those documents in court and sort of making a mess. Good to have that note handy, which you can very quickly refer to, as we would have all learned from our counsels. And I think one other sort of tip that I have learned the hard way is that don't poke and prod your counsel when he's arguing the matter. Trust him to argue his case in his way. If he has missed anything out, I think point out at an appropriate time. Don't disrupt the flow. Don't pull his gown and his jacket, because a decent man like Kamal may not say anything, but somebody else may just whack you in court. So it's a good idea to not do that. So I think those are just some quick tips on how to really efficiently conduct a final hearing from somebody who's assisting the counsel.
Correct. Thanks, Kingshuk. That was a good input for the juniors as well. But I would also now feel that now the days have come, especially now that one has to go through the final hearings before one goes through it. I would feel that the necessity is that one would prepare written submissions which are going to be presented before the court. And to my mind, the healthiest way of doing it is having the counsel and you sitting together, means the attorney and the counsel sitting together and preparing these written submissions or exchanging it, whatever suits as per the time constraints, etc. But the written submissions are essential. So what would happen is that at least I have formed this practice where we prepare written submissions, discuss it with the counsel, the counsel who is a senior who wants to appear or a junior as well, as to know what you are going to argue, to discuss with them in order to find out if they have some additional points to add, because there are times where because it's been a lot of time that has passed between the previous hearing and the next hearing. You may have missed a point or two. So it definitely helps in preparing a written submission together, so that if there is a point which is discussed and has not been argued, at that point of time or just before the final hearing is completed, it may be of help and use to both the client, the attorney, and the counsel to bring it out. Okay, now this written submissions also help the courts. So when you are presenting your case, you could hand over the copy of written submissions, which written submissions are essentially, as you pointed out, Kingshuk, are nothing else but dates and events, along with documents and your supportive arguments, assertions, your answer to each of these issues. There are different ways of preparing written submissions, and again, that by itself is another topic which would take and a lot of explanation, and it would probably take a session to explain how a written submissions has to be made. But needless to say, the brief dates and events are very, very crucial, and the points of arguments which you would like to present in the manner in which you would like to present should be put down so as to be able to enable the court also to understand where you are leading it to. So, when there is a bulk of papers, which in normally most cases there are, it would be much easier for the court if these kind of written submissions are given before the hearing. So I would stress emphasis and I request all the advocates and the learners to formulate a habit of preparing written submissions before the final hearing of the matter. Now, this written submissions, I would feel, should also include all the case law which you are relying upon. As you rightly said, you must create a whole file, an extra set of judgments, etc., and keep them ready. And at the same time, you must, include your case law and point wise, probably, when you are giving your submission, so as to make it very simple. There are times when, if even if a senior is not there and if a junior has to argue the matter as Kingshuk, there are times when someone has to take over from the senior because of his inability to come or otherwise. I'm taking that in consideration as well. Then a junior is able to take over the argument at that stage and is not embarrassed before a court if the court insists that he should continue with the arguments. Then that point of time, these kind of submissions would be of great help. So I would say that it would give a lot of comfort, a lot of confidence to a junior, and this should be considered. And of course, after this written submissions and the arguments are complete, we do require, now it is necessitated that we would prepare another set of written submissions, which would also be tendered to the court. But this particular written submissions would have, in addition to what you have already stated, whatever has been argued by the other side and your response thereto, which would be included, so as to give the court an overall view of the entire hearing of the matter, along with the case laws which have been discussed at the time of the arguments. So this is how the entire conducting of the trial is completed. And then after having submitted your written submissions, you await the judgment, and hopefully in your favor for each of the parties. So this is how it ends. And I would say I'm thankful to all of you. And this is how I would like to end the lecture. Thankful to all of you to listen to my talk. And I hope this has been useful. Kingshuk, would you have anything more to say on this?
No, not really. I think just some closing comments that, whilst all of us are very quick to blame our judiciary for backlog, pendency, delays, but I think at some level, as lawyers, it's important to sort of take responsibility and let's help the judiciary and, not just blame it. and one way of doing it is really conducting a trial and a proceeding efficiently. I think, and that's what Kamal, you have taken us through today and last week. And if we really do conduct a trial efficiently, I think it's going to go a long way in helping, you know, actually close matters quickly and sort of getting over these backlogs. You know, and as the cliche goes, you know, we are officers of the court, and as much as we would like to blame others, but we are responsible for the prevailing state. So let's do something to change that. I want to end on that positive note.
Whether on the basis of an admission of liability made by a guarantor, not a party to a suit, whether the court can proceed to pass a decree on admission against the borrower in a suit initiated by a bank against the same borrower.
So I would like to say that an admission made by a party, not a party to the suit, would not be binding on the parties, because that particular admission would be not an admission by the party themselves. A suit filed between two parties get an opportunity of being tested by way of a trial. So there would be cross-examination, so of a party who is trying to state certain facts. So if a particular party has stated a particular fact who is not a party to the suit, then that particular admission is definitely not an admitted fact for the purposes of this particular suit.
Yeah, I mean, you may not, you won't get a judgment on decree in terms of the provisions in CPC, yeah. But you could obviously use it in evidence. But I think your question is, can you get a decree on admission? No, I think you can't.
Okay. If an affidavit of evidence is improved and no utter of the fact in the suit, then how to bring such omissions on record in cross? In a criminal trial, omissions and contradictions are proved through IO.
So essentially, we are looking at civil cases, and if a particular omission is there, then there is a further examination in chief. So it depends on when that omission comes to light. So suppose you have already filed an affidavit of evidence, okay, and you discover that a particular fact has not been stated, or an assertion has been left out, or a particular event has not been described in the affidavit of evidence. There is a process where you can, before the commissioner or the court, you can seek liberty of the court or the commissioner to lead further evidence. So this is the stage where you can bring in your further evidence and bring about a clarification by asking further examinations, questions and examination, and bring that evidence on the record. So this has been done several times. So, this is the way that you can cover up the lacunae, and the court has allowed in most of the cases these kind of leverage. Yes?
But Kamal, would we still have to, and this is a question that I was asking myself, would we still have to at least show some element of foundation in the pleadings?
It depends on what the facts and documents are brought in. There are times when these things are not referred to or relied upon in the pleadings as well. But it so happens that because it has been brought out, sometimes, like this is the question where a particular thing has been brought out in cross-examination. So, you may have been asked to file 2 affidavits or maybe all the 3 affidavit of evidences, and you have not been able to cover this aspect. So then through the second witness, you may have to, lead further evidence. And therefore, it is not something which is relevant to the documents and facts that you have stated then, but it has come out in the cross-examination of your previous witness. So that's where, because otherwise most of it is covered. As you said that, Kingshuk, we normally see that the party is, cross-examined literally before filing the affidavit of evidence. So you try to dig in and delve into every aspect of fact and document, but there are aspects which come out in a cross-examination and which you cannot thereafter prove. but you may have evidence or witnesses who would be able to prove that particular or disprove that particular fact or document which has come into light by virtue of the cross examination of the previous witness. So
Right.
this is what leading further examination in chief of the second witness who is not yet stepped into the box, or the last witness rather. You can always bring this in, but once the evidence is complete and they have been filed, you cannot.
Right. Thank you.
Yep.
Right. One more question. Considering the limitations of cross before a commissioner, would there be benefits of bringing in a proviso for video recording of cross before the commissioner?
I would suggest that yes, it would definitely help. I would feel that this recording by way of voice memos or by way of video recording would definitely help in curtailing. But that is again for the legislature to legislate and bring it into our system by way of an amendment or otherwise. Because as we earlier pointed out, there are several lacunae in the commission, the way the evidence is being recorded before commissioners. So one of these methods of amending the CPC and bringing in such a provision would definitely help, and it would be certainly useful for the court before deciding its objections to see the demeanor not only of the witness but also of the persons conducting the trial. So this would definitely help the court to come to a just conclusion, and would not only have to rely upon the arguments made in court during the final hearing. It would be a
Great.
welcome amendment.